Mr. Glazier, I am going to open up a breakout room and assign it. For you, he's in jail zone 2. All right. All right, Mr. Fry and hold on. All right, Mr. Murphy. Nope, there he is. And who's my prosecutor in law? Okay, are you ready on that one?
Yes, sir.
Okay.
I apologize for being late.
It's okay. Okay, so now we are back on the record in the matter of the people of the state of Michigan versus Bruce Love. I have Matthew Murphy appearing on behalf of Mr. Love, and I have Mr. Gumtoe, Daniel Gumtoe, appearing on behalf of the people. So there was a sentencing memorandum that was prepared on Mr. Love. And have you, Mr. Gumtoe, had a chance to read and review that?
Yes, Your Honor, I have.
Okay, and
Will agree with the recommendation in the sentencing.
you agree with the sentencing memorandum?
Yes.
Okay.
The PSI. Yes.
I think he's trying to clarify, he agrees with the recommendation from the probation and then.
Okay, have you had a chance, Mr. Murphy did a sentencing memorandum, have you had a chance to review that?
I have not yet, Your Honor.
Okay, do you have a copy of it? Okay, so have a seat, review that. I am going to, let's see, Mr. Rasco, are you ready to proceed now?
Yes, ma'am.
All right, so Mr. Rasco, you now had a chance to speak with your attorney.
Yes, ma'am. I appreciate it.
Okay, are you satisfied with your attorney and the advice that he's given you? All
Yes, ma'am.
right, Mr. Glazier, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report from district court?
No, Your Honor.
All right, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No, Your Honor.
All right. Before the court passes sentence, is there anything you'd like to say on behalf of Mr. Rasco?
Your Honor, just on behalf of Mr. Rasco, the recommendation indicates that they want him on probation for 18 months, basically to pay some fines and costs, I guess, and have a curfew. But we'd asked the court, the probation officer also indicated she considered just asking just to give him credit for time served. He's spent 142 days in jail, and these are 1-year misdemeanors. We asked the court to consider what he originally thought about doing, giving him just credit for time served. I'm just a little worried about Mr. Rasco screwing something up and doing more jail time, and he's not done well on probation in the past, and we'd ask the court to consider just giving him the credit for time served.
All right. So, Mr. Rasco, the probation officer, Westgate, actually did state at one time she had considered giving you credit for time served, but she also, I don't think they were recommending probation for fines and costs. I think she was recommending probation because of services, because her life is kind of spiraled out of control and addiction issues are really concerning. So are you asking for the court to give you credit for time served, or would you like some recovery services?
I'm asking for credit for time served. I don't want to sound disrespectful towards you or towards them at all. If you decide to give me that, I'll take responsibility and I'll do my best with it.
So, Mr. Rasco, you understand, even if I give you credit for time served, you know, we have a lot of programs in Lenawee County, the Sheriff's Department, as well as, well, the one that started it was Adrian Police Department, the Sheriff's Department do it now as well. But if your addiction is such that you're having trouble and you want help, you can walk in the front door and they will find you placement in an inpatient program. Do you understand that?
Yeah, where would I go to, you said?
You walk right in the front door of APD and the Sheriff's Department, and if you tell them you need help, they have the Angels program, they will find you placement and assistance.
All right, thank you, ma'am. I appreciate it for the information.
Because I also worry about you as well. But you do have the right to request a jail term instead. So, anything else, Mr. Glazier?
No, Your Honor.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication of the law, and protection of society. So, this sent to the court, you will receive credit for time served. I do have to assess court cost, or not court costs, but crime victim rights fee and estate costs. And there are 2 files, and on each file you pled guilty to domestic violence second. So let me find it. So on each file, there'll be a $50 state cost and a $75 crime victim rights fee on each file. So that would be a total of $125 on each file. And I would just ask that you pay that once you're released. Mr. Rasco, you know, you've had a lot of opportunities for services and you haven't been able to take advantage of those. And I just hope that going forward, you seek them out yourself. You do have the right to appeal the sentence, and we're going to get you at the jail 3 copies of your notice of right to appellate review. They'll have you sign 1 copy for our records. The other copies are for you. If you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Do you understand?
Yes, I do, ma'am. I appreciate it.
All right, and Mr. Rasco, obviously, if you walk into the courthouse to see me and you need help, we'll find you help too. Mr. Coast is a wonderful resource. All right?
Yes, ma'am.
All right, thank you. All
Thank you, ma'am.
Thank you, Your Honor. That's all I have with you.
right, have a good day.
Yeah, you too.
All right, are you ready, Mr. Love?
Yes, Your Honor, thank you for giving me an opportunity.
Oh, not a problem. All right, so this is back on the record in the matter of the state of Michigan versus Bruce Anthony Love. Mr. Murphy filed the sentencing memorandum on June 3rd of 2025, which after I read it, I realized I had read back in the beginning of June when you filed it. It's just probably on my desk somewhere. So in this, Mr. Love objects to the agent's description of the offense in the pre-sentence report. There was a statement, Mr. Love had received a trespass warning back in 2023 from Erie Park. No evidence was presented at the preliminary exam, nor the trial that a person with actual authority to do so decided that Mr. Love was to be excluded from Erie Park, or that actual notice of that decision was served upon Mr. Love. Officer Robinson testified that he told Mr. Love that Mr. Love was trespassed from the park, that Officer Robinson was the person who decided that Mr. Love could no longer set foot in Erie Park and gave no end to this exclusion of Mr. Love from public property. So with regard to that statement, I'll allow Mr. Gumto any response.
I believe the issue of Mr. Love being excluded from parks was litigated prior to trial in this matter. Was it not? And the court ruled that it was a legitimate ban?
The trespass charge against it was dismissed. This was never addressed other than in this case on the preliminary examination. And as I had said, at the preliminary examination, that's what was testified to.
So the trespass would have been in district court?
Yeah, that case was dismissed.
I thought that, was it not litigated at some point, Matt?
No, it was dismissed.
We would uphold that that Mr. Love's ban from the parks is legitimate and proper.
Okay. Statement, the kid replied by saying he is not. He was referring to Mr. Love, who was yelling in the background and making angry grunts. Officer Robinson then approached Mr. Love after the child says he's not. The body cam footage depicts the officer asking the child, what's he doing? To which the child responds, oh, when you just pulled up, I just got up there, and when you pulled up, he was just acting like that. Furthermore, the officer testified in the body cam footage showed that a couple of other members of the community that were not originally there with Mr. Love assembled together with Mr. Love to protest the actions of the officer that they perceived to be wrong. So what is your objection on that one, Mr. Murphy, exactly?
Because the statement doesn't continue to say everything that the child had said. It ends with, because I think the child's, what he said on the body cam, the entirety of that statement needs to be put in, which is the child was saying that Mr. Love was acting that way once the officer came about, that he never observed Mr. Love acting that way prior to the officer. He said that when you pulled up, he started acting that way. And that's why in the statement from the agent, it reads as though the child says, oh, he was misbehaving anytime before that. And I wanted to clarify it on the record, right, in the statement.
All right, so in the body of the pre-sentence report, there is a description of the offense, and I think, so on May 12 of 24 at approximately 1500 hours, Officer Robinson of the Adrian Police Department observed Bruce Love at Erie Park. Bruce Love had received a trespass warning back in 2023 from Erie Park, and at this point, Mr. Love was advised not to be in the park, and a report was done. So you're referencing the 2023, that statement there.
That was the first contention, the first point when we had.
Okay.
And then the second point is that
Well, hold on. At approximately 1900 hours, Mr. Love was back in the park again and was told again not to return. So Mr. Love, what they're saying is that the officer advised Mr. Love on this date not to be in the park, correct?
yeah, on this date, he advised him sometime earlier than.
And then Mr. Love left to stand on a sidewalk, and the officer sat at the park to make sure he did not return. While he was standing on the sidewalk, he began to yell and curse up and down the street, yelling, bitch, that he will beat my ass and take my gun. He stated for the officer to come over to him so he could assault him. Mr. Love then came closer to the patrol vehicle and continued the same threats in the same disorderly manner by yelling. This lasted for several minutes. He then went near the sidewalk to Erie Street Park. While over there, and we were able to view him on a sidewalk, not at Erie Park, but at a sidewalk. While over there, a kid came up to the officer and asked, what are you doing? At this time, the officer activated his body camera, and he told the kid that he was making sure that everyone was behaving at the park. And the kid replied by saying he's not, referring to Mr. Love, who was still yelling in the background and making angry noises. Officer Robinson then approached Mr. Love. He told Mr. Love he was under arrest for disorderly. Officer Robinson went to get a hold of Mr. Love's hands, and Mr. Love swung his left hand and grazed the officer's face, mainly hitting the mic and knocking it loose from where it was clipped. Mr. Love had tensed his arms as to prevent the officer from placing him in handcuffs. Eventually, he was placed in handcuffs, and 2 packs of cigarettes, a pocket knife, marijuana, and 2 lighters were removed. Okay, so your first objection is that.
Again, to the fact that he was trespassed back in 2023, that was the first contention.
Well, I think all they're saying is he had previously received a trespass warning back in 23. So he's objecting to that being in there as to relevance to this event. Is that correct, Mr. Murphy?
Well, I mean, the situation is relevant to what's going on with Mr. Love. I don't know how else to express that.
No, I'm saying, are you saying the fact that he received a trespass warning in 2023 shouldn't be in the PSI because it's not relative to this event?
Well, it is relative to Officer Robinson's actions. I don't contest that Officer Robinson told Mr. Love, you can't be here anymore, you're trespassed. Their objection is that it was an official trespass that Mr. Love should be abiding by moving forward with what I guess.
So you're saying if a police officer says you need to leave the park, you don't have to?
Your Honor, that's different than saying you can no longer step foot in this park and you're trespassed from that park. And that's going to be what I'd argue. Again, that's not part of the correction of the PSI, which is why, again, I understand here there was a trial, a bench trial, and Mr. Love has a lot of objections to how things are phrased in pretty much the entirety of the statement. So obviously I couldn't come and say we object to the entirety of the statement. I tried to pick out things that we could show on body. And again, and from the transcript and what was said down in district court and what was said in front of Your Honor. And so that's why in regards to the trespass, I don't contest that Officer Robinson said back in 2023 said you can't be here, Dairy Park. I'm contesting that it would be considered. I guess pardon me, my argument on that, Your Honor.
I guess I'm just trying to understand because I think they're just stating that he did have a trespass warning in 23. I don't think that trespass warning continued 2 years later.
Oh, they believe it does, Your Honor. And at the trial, as Mr. Gumtard argued, they believe that Officer Robinson could have arrested Mr. Love at that time for that trespass violation. If you follow on the body cam, Officer Robinson was reviewing the evidence of that trespass. You could see him looking at that on his phone. So that's central, Your Honor, again, to the what Mr. Love's been suffering under. So sorry, but that's what they had argued, that he could have been arrested under the Trespass Act too. And so
all right, so here's what I think. I'm going to adjourn this because I think Mr. Gumto is going to need time to clearly respond because I have a bunch of sentencing this morning and I think this is going to need more time. I don't want to short Mr. Love any time on this. So Mr. Gumto, I'm going to move this. Mr. Moore?
I just want to just explain a narrative on probations, from where it comes from me and why it's in
I don't
there.
have time this morning, so
Okay.
I am going to adjourn this. Ms. Adams, do I have a date, like anywhere, like 2 weeks out?
I just want to make sure Mr. Love has placed an objection.
No, I think to what, being adjourned?
He's just
Because I
doesn't
know I got cars and stuff that got me out on bond, you understand me? They want to change the car.
I can't hear you.
I said they got cars, vehicles out on their bond for me. But I've been going through this stuff for 2 years, man. They want to get rid of their cars.
I'm not gonna adjourn it very far.
Okay, but
I'm not gonna adjourn it.
I'm losing my mom. It's just so much going on in my life.
I know, but I don't want to do you a disservice in this.
I understand.
So,
Well, but
Ms. Adams, I'm looking for a date about 2 weeks out. Ms. Adams, are you in the office?
Sorry, I was talking and didn't unmute.
right,
2
can I
weeks
get
out
it-
does not look good, but I mean, we have like,
Can I have the book real quick? And I need Miss McRae.
Okay.
All right, Mr. Love can also Zoom.
last time we had asked, you said you had to be here in person, but the next,
I mean, if he's having difficulty getting back and forth to cars, that's fine. I can actually do 11 a.m. on June 17.
People are available at that time, you know.
That works for the defense, Your Honor.
All right, so I'm gonna set this to June 17 at 11 a.m. And Mr. Gumto, you got enough time then to
Yes.
file a response? Okay.
Thank you.
All right, so Mr. Love, you're not able to find transport, obviously you can zoom in, okay? All right, so we will see you back on June 17 at 11 a.m.
Is there gonna be a notice?
Ms. Adams, can I get a notice from Mr. Love?
Thank you, Your Honor.
Thank you.
Yes.
All right, so Mr. Love, just have a seat in the courtroom, we'll get you that notice, all right? Okay, so here, Mr. Santiago. So the last thing I have is Mr. Stinson's, but,
We're ready, Your Honor.
okay, hold on. What are you here for? Oh, yeah. Let me take care of Demolan real quick, because I'm waiting to get your motion back.
Just, is he on Zoom? 'Cause
Yeah,
if I can talk with him.
yeah, go ahead and back. I think he's, hold on, let me check. I think this is him. Mr. Oh, he's not connected. It is him. Go ahead and log on. I know it's gonna be him. Just gonna connect him to audio. Can you guys maybe step in the hallway for a second if you're gonna have a conversation? We'll bring the notice out to you.
Thank you, Your Honor.
Thank you. Yes. Here.
I can take a picture.
Mr. Demolan keeps dropping in and out. Okay. It's here. So Mr. Dagenberg goes in, Mr. Demolan's kind of coming in and out. I think he's trying to connect. Let me bring him back in again. He's struggling. He did connect earlier, but he had kind of bad reception. So
Okay, I'll just be.
if you have a phone number, let's see, he's back again. Let's see if he can connect to audio, because he can't call in if he can't connect on Zoom.
Sorry about that.
Thank you, Mr. Murphy.
For what?
Your timely filed motion and your patience this morning.
And I was hoping he wasn't gonna get too worked out.
Okay.
Thank you, Your Honor. Have a good day.
All right, he's back in, Mr. Dagenberg goes in, so hold on. See if he can connect to audio. Oh, Mr. Demolan, can you hear me?
Yes, can you hear me?
Yeah, you're kind of breaking up, so you may need to move to get to better reception. But I'm gonna open up a breakout room for you and Mr. Dagger Margosian to chat. And then I'll be right back with everybody. Give me just a moment. Mr. Demolan, did you go into the breakout room?
Nothing came up.
Okay, I'm gonna do it again.
Okay.
And then Mr. Fry and Mr. Sneed, I'm ready to go on Mr. Stinson. Okay, so Mr. Degemer goes in, Mr. Demolan wasn't able to get in. Oh, he's gone again.
But I wonder,
Okay.
I wonder if you could call in and not just not have the video portion of it.
Well, he can call into Zoom for audio.
Yeah, is the court okay with that? I mean, we could do the sentence that way.
Yeah, just give him, if you can call him and give him the number to call into Zoom, that's fine.
I will.
And Your Honor, regarding him, he didn't show up for his drug testing here on Monday. I know I talked to Mr. Coase and
Okay,
then also
I'm gonna go on, hold on. So Mr. Degemer goes in, go ahead and reach out to him. Let's do Stinson real quick so I can get MBOC on their way. All right, so Mr. Fry and Mr. Sneed, this is in the matter of the people of the state of Michigan versus Devontae Stinson. File number 25-22218FH. It is the date and time set for sentencing. Mr. Stinson, have you had a chance to read the pre-sentence report?
Yes, ma'am.
Okay, have you had a chance to discuss that with Mr. Fry?
Yes, ma'am.
All right, very good. Are you satisfied with Mr. Fry as your attorney and the advice that he has given you?
Yes, ma'am.
All right, so we're gonna start first with the sentencing memorandum that was filed. So Mr. Fry, if you would like to go ahead and present your argument.
Yes, Your Honor. So my client pled to felony firearm, mandatory 2-year sentence. Our objection was just to the line in the PSI, which stated that sentence shall run consecutive to all sentence for which he is currently serving. So we disagreed with that language, and I don't think it conforms with the law. As we cited in our memorandum, People v. Clark, felony firearm is only consecutive to the underlying or predicate felony committed that was associated with the felony firearm. In this case, there was none. My client just pled to the felony firearm, so there was nothing for it to be consecutive to. Then the other issue was that he was on parole at the time of the offense. There is a statute, MCL 768.7A2, which says basically that for a crime committed on parole, the defendant must complete their previous sentence first before starting their new sentence. But in Wayne County Prosecutor versus Department of Corrections, which I cited, it interpreted that to mean that the minimum sentence of the previous sentence has to be completed before starting the new sentence, not the maximum. That case was kind of all about that statute, minimum versus maximum sentence. The conclusion in that case was that if a felony is committed, new felony is committed while on parole, the new sentence would start following completion of the minimum sentence of the original case plus any time for parole violation sentence. So in this case, my client did serve the minimum sentence of his previous felony. He was was released from jail or prison, I mean, on parole when this new sentence occurred. So he's already completed the minimum. So my understanding of the law, his sentence would be consecutive only to parole violation for his previous sentence. So it wouldn't be for all previous sentences. It would just be for parole violation for his previous sentence. So it's just a flat 2 years. I mean, he was on parole, so my understanding of the law is not entitled to credit. But you know when his sentence start, I guess is the issue. And my understanding of the law is his 2-year sentence would start following completion of parole violation. Thank you.
Okay, and then, Mr. Sneed, I greatly appreciate, your taking the time this morning to proceed on this. So, Mr. Sneed, what would the people's position be?
Well, Your Honor, I think we agree that the result here is that the sentence in this case shall commence on or about January 23rd of 2026, which is when the supervision discharge date is by the Michigan Department of Corrections. When Mr. Stinson had his parole revoked, he was returned to incarceration. He had a right to demand a revocation hearing. He has not demanded that revocation hearing to date. It's been consistently adjourned. If he held the revocation hearing, in all likelihood, he would be found guilty and his incarceration would continue to January 23rd, 2026. If he continues to adjourn it, fine, but the MDOC will still have jurisdiction over him and can hold him until the supervision discharge date, which is January 23rd, 2026, according to the MDOC records. And so we agree the plain language of the consecutive statute 768.782. I agree that says exactly what Mr. Fry says, that when people commit felonies while on parole, their sentence begins when the remaining portion of the term of imprisonment imposed for the previous offense ends. And here our position is that's the MDOC supervision date. Mr. Fry's trying to draw the distinction to say that that just applies to the end of when a parole violation would occur. And again, here, that's going to be January of 2026. I'd also like to point out that we did put that term on record at the plea hearing. So if Mr. Stinson would like to withdraw his plea at this point and set the matter for trial, the people wouldn't have any objection to that.
All right, anything else, Mr. Fry?
No, Your Honor, we just want the sentence, I think, to comply with the law, which, you know, can't be consecutive to a previous sentence, you know, as the PSI seemed to indicate, you know, it would just be consecutive to a parole violation. So, I mean, that is our whole point, to make sure this is done right. And that's, in our opinion, how it should read. Thank you.
Okay, so this is the first time I've ever dealt with this issue, either as a defense attorney, an attorney, or a judge. So it's just not a common situation. So in this case, Mr. Stinson pled guilty to carrying or possessing a firearm when committing or attempting to commit a felony under MCL 750.227B. All other counts and habitual supplements were dismissed. The statutory sentence for this offense is a mandatory 24 months or 2 years of incarceration. Mr. Stinson is currently incarcerated on a parole detainer. detainer, and Mr. Fry correctly stated he had completed his minimum sentence on his previous conviction. I did review this, and I also had my judicial attorney review the case law on this under MCL 750.227B, parent 3, a term of imprisonment prescribed by this section is in addition to the sentence imposed for the conviction of the felony or the attempt to commit the felony, and shall be served consecutively with and preceding any term of imprisonment imposed for the conviction of the felony or attempt to commit the felony. So that would apply to, had he pled to, you know, another offense on the file along with this felony firearm, obviously this felony firearm would stack on that. So on, let's see. So under, we did review the case law on People v. Clark, 619 Northwest 2nd, 538. The Supreme Court found that from the plain language of the felony firearm statute, it is evident that the legislature intended that a felony firearm sentence be consecutive only to the sentence for a specific underlying felony. In Wayne County Prosecutor v. Department of Corrections, 48 Northwest 2nd, 900, 1996, the prosecutor in that case had argued that the defendant must serve the maximum sentence on the previous conviction before the new sentence starts if they were convicted of a new felony while on parole. Michigan Supreme Court in that case did hold that the defendant's new sentence would begin after the defendant served the minimum sentence for the previous conviction plus any additional for a parole violation. In this case, the defendant was not convicted of a predicate offense with his felony firearm conviction. Therefore, it is not a consecutive sentence that can be applied under the felony firearm statute. Furthermore, the defendant, while on probation, has already completed his minimum sentence from his previous convictions. We looked that up, and he has not been sentenced to any additional time for a parole violation. Based on that and that information we were able to obtain, I'm going to agree with Mr. Fry on this one. And like I said, I've never dealt with this issue before. And so his sentence would not be consecutive because there has been, for the reasons stated. So, Mr. Fry, do you wish to explain or challenge the accuracy or relevancy of any other information in the pre-sentence report?
No, Your Honor.
And Mr. Sneed?
Well, Your Honor, I just had a few questions. You said, I think it's understood that the sentence is not consecutive under the felony firearm statute. But under.
And then with the parole violation, he's already served his minimum on that prior offense. And then he's not been given any more time. So he's like not.
But his parole's been revoked.
I understand, but I'm going to have to follow Wayne County Prosecutor versus Department of Corrections on that one.
Also, Judge, we had a plea bargain that included a sentencing agreement that the sentence would commence on January 23rd, 2026. That was placed on record at the plea hearing.
Mr. Moore?
Yes.
So on Mr. Stinson, is he currently serving a sentence on anything other than
So I could look at just real quick on my explanation of this in the past is, you know, he's been returned to prison. He's delaying his parole violation hearing. What will happen upon this sentence is that they're going to start his sentence. They're going to stack it. They're going to stack the, so let's just say his out date on the max is 2020. They'll stack it on here 2022, but they'll start this sentence immediately, consecutively, but upon the sentence. That's usually how that works. There's not going to be, because he's delayed it, there's not going to be a parole violation hearing where they're going to, add an additional year or something like that because he's delayed it pending this. Does that make sense?
Has he already served his minimum though?
Well, he may have already served his minimum, but upon sentence, they're going to start the new sentence, but the maxes will stack. The sentence will stack on top of the other one, but he'll start the new sentence immediately. In my recollection.
Okay, so I think at this point, obviously this was filed June 10th. Mr. Sneed has not had a lot of time. At this point, it appears to me Wayne County Prosecutor versus Department of Corrections would hold since he's already served his minimum. But I can adjourn this to 11 o'clock on June 17. Mr. Sneed, if you want to do some research.
No.
Thank you, Judge.
All right, so Mr. Stinson, are you available June 17 and 11, Mr. Fry?
I'm in an evidentiary hearing with digital favor.
What time is that?
9 to noon.
Noon. Are you available at 1:30?
Yep, I can do that.
Mr. Fry or Mr. Sneed?
June 17th at 1:30. Yeah, I'm available.
Okay, so we'll do June 17 at 1:30 and yes, Mr. Sneed.
Would it be possible to obtain maybe just an audio recording of the plea hearing versus a transcript to listen to?
It's on YouTube too.
And then secondly, would the court entertain a motion to withdraw the or set aside the plea and plea agreement based upon?
Not at this time. If it's just a mistake of law, then, I don't know, but obviously we can address it after you review the case law. Okay. All right. So yes, you can get an audio from Ms. Spade. You can also just look back at when he pled and look at the YouTube too. Okay.
Okay. I will.
Yeah. Either or is fine. All right. So Mr. Stinson, we will do our best to get you back June 17 at 1:30.
Can I ask one
okay?
question? Can I ask one
Yes,
question
sir.
real quick? Right. So if he goes back and we push this back from the 29th to today, all the way into the 17th, right? And the plea agreement on record does not state what he just said. Does that just eliminates whatever he just said to the point of my time would just be the 2 years and consecutive to any violation time that I would have if I would have violation time? Or is it, what's going to happen? Because that's not an agreement that I agreed to.
Okay, so Mr. Stinson, I don't even remember what was put on the record today, but I have no reason to doubt any of the attorneys. We'll all review it. We'll come back and we'll discuss it at great length at that time, okay? Mr. Fry, do you want to break out room with your attorney to give him more information?
Yes.
And talk to him today?
Yep, I can do that. Yeah.
Yep. All right, so we'll see you back on June 17 at 1:30. Mr. Stinson, I'm going to put you in a breakout room with your attorney and he can explain this to you. And then when you're done, you can just disconnect, all right? All right. So Mr. Dagger-Margosian, I have Mr. Demolan. Mr. Demolan, can you hear me?
Yes, can you hear me?
Yep. So I've got him here. Did you talk to him on the phone?
Yeah, we're
Because I could leave the courtroom and let you talk to him.
I appreciate it, Judge. We're ready to go.
Okay. All right. So hold on. Let me put Mr. Stinson away. Mr. Stinson. There's Mr. Oh, there's Mr. Demolan. That's Mr. And I don't even know who that guy is. Oh, he might be the pickup. Okay. Hold on. Let me call him. So Mr. Demolan, I'm gonna have Mr. Moore and Mr. Coast kind of stop their video, and I lost them. Hi, do you have a Joshua Coleman?
Joshua Coleman, I do.
Is he on your floor or downstairs?
He is downstairs.
Oh, do you want me to call down there to get him?
Sure.
All right, thank you.
Yeah,
Bye.
no, bye.
Hi, this is Judge Anzalone. I'm ready to see, there you go, Mr. Coleman.
Joshua Coleman, you got it.
All right, thank you. Bye.
You're welcome, Amanda.
All right, so, Mr. Demolan.
You're,
Can you
What
go
I-
outside?
what's that?
Can you walk outside? Like, where he's at in his house is bad reception?
I know. What I was gonna suggest is like a couple of years ago, I think in Washington, there was a sort of situation like this, and we had from your desk called a person so that we can get him on. I don't know if that's something you want to do, but
You gotta write down his number for me. You wanna post it? That's,
yeah.
you gotta post it. then? I don't wanna put his number on.
Thank you.
I never know, you
I
gotta dial the
don't-
one, you
I-
gotta dial the.
I do it.
Mr. Demolan, take my call. Oh, there you go. I'm gonna end your, Mr. Demolan.
Yeah.
Okay, I'm gonna disconnect your YouTube, all right, or your Zoom, okay? You're welcome. All right, so we are on the record in the matter of the people of the state of Michigan versus Joshua Demolan, file number 25-22183 of Michael Dagger Margosian appearing on behalf of the defendant. I have Darren Coast appearing from our pretrial services. And Mr. Coast, do you have an update on Mr. Demolan?
Yes, Judge. He was drug testing with me every Monday and Friday. His last drug test was on 6/2 and it was negative. But he did fail to test last Friday and he failed to test this Monday too. And now he's by Zoom. It might be a good idea if we actually have him drug tested today.
That's fine. If I can give some light to the court. So when I was speaking with Mr. Demolan today, he said, look, Mr. Coast told me I do not have, at our last court date, Mr. Coast told me that I do not have to drug test. And I wanted to make sure. And so I looked back on my notes, and what I think happened is the notes that I have, it says, Mr. Coast says that defendant is doing well, is fine to dismiss the contempt that had been hanging out there. So I think that Mr. Demolan thought that that's what that was. I'm sure that Mr. Demolan is fine with testing today if that's required, but I don't think that he's doing this on purpose. I think he genuinely thought that the testing requirement was dismissed, whereas in actuality it was for the dismissal of the contempt for the failed test a while ago.
Judge, it's my
Okay.
understanding he was supposed to be sentenced, I believe, last week. He didn't show, so we moved it to today.
Right.
So if he was sentenced last week, then that is correct. He wasn't going to test anymore, but because it was moved to today, I'd wanted him to test, obviously.
Right.
Yeah, he failed to appear at sentencing.
Okay. So he did appear today. Is he still in Waseon? Ohio? Mr. Demolan, you live in Waseon?
Yeah.
Okay, and where is he typically testing, Mr. Coast?
Judge, he was actually drug testing with me every Monday and Friday.
Your
The
Honor, if I
last
may,
drug, the last drug screen I have with him is June 2nd, which it was negative.
Your Honor,
Yes,
he,
Mr. Moore.
he reported to me that he's working every day for Solarski's, which is out of Adrian. So he's up here.
You working for Lasarski's right now, Mr. Demolan?
No, I actually just lost my job because of, with the drug testing. Walt didn't, I was having to come in late and he wanted me there early, so he had to let me go. But, I'm currently in the process of getting a job for, Clay Meadow Estate.
Where is that? What city is that?
That's in Fayette, Ohio.
Okay. All right, so, all right, I'm just gonna proceed with sentencing today. Okay, so, Mr. Demolan, Ms. Spade, are you picking up Mr. Demolan?
He needs to just speak up a little more.
All right, so Mr. Demolan, because I have you on speakerphone, I'm definitely gonna need you to speak loudly, so you're gonna kind of feel like you're yelling, okay?
Okay.
All right, so is that better?
Yes.
Okay, so Mr. Demolan, have you had a chance to read and review the pre-sentence report?
Yes, I have looked it over and seen the report.
Okay, and have you had an opportunity to discuss that with your attorney?
No, but
Josh,
Mr. Demolan, did you speak to Mr. Degger Margosian on the phone today?
Oh, yeah, yeah.
And did you guys talk about the recommendation and what's in the report?
Yeah.
Okay, so you've had a chance to talk to him about the pre-sentence report?
Yeah.
Okay, are you, it's okay. Are you satisfied with Mr. Degger Margosian as your attorney and the advice he has given you?
Yeah.
All right, and Mr. Degger Margosian, hold on one second. Who is the attorney on this one? Are you the attorney for Joshua Coleman?
I am, I think.
Because I got him on Zoom. Do you mind handling that after this?
I can.
Okay, all right. So, Mr. Degger Margosian, with regard to Mr. Demolan, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, no challenge.
Okay. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
No.
Probation office has computed the minimum sentencing guidelines to be 0 to 11 months. Do you agree with that computation of guidelines?
No challenge.
All right. Now, Mr. Coast, prior to him missing those tests, which we did dismiss the contempt, had he done well in his testing?
Yes, Judge, he did show up and he was negative each time in the last couple of months.
All right, excellent. Thank you. All right, before the court passes sentence, is there anything you'd like to say on behalf of your client?
Your Honor, I would just ask the court to file the recommendation for probation under 7411, as that was part of the agreement. Mr. Demolan has been compliant on bond, except the one test back in I think April. That contempt has already been dealt with. So I guess I would just be asking the court to sentence him as the recommendation goes.
All right, Mr. Demolan, is there anything you'd like to say on your own behalf?
No, Your Honor.
All right. So, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been set upon the record at this hearing. The reasons and criteria for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and protection of society. It's the sentence of the court that you'll be placed on probation for a period of 18 months. During that term of probation, you will obey and comply with all provisions in your articles of probation. You will pay $750 in court costs, $130 crime victim right fee, $68 in state costs, $60 DNA fee. There is a $30 per month supervision fee, $60 if we have to use a tether. I will give you credit for 26 days already served. During that term of probation, you are not to use or possess alcohol. You are not to use any illegal controlled substances. You must comply with testing. You're not to commit any new offenses or engage in assaultive behavior. You must report as required to the probation department. You must submit to a search of your person and property, including your vehicle, residence, or computer without need of a warrant if the field agent has reasonable cause to believe you have items which violate the conditions of your probation. They are allowed to enter your home for purposes of probation monitoring. You must report any police contact, change of address, or change of employment to them within 24 hours. Now, obviously, you live in Ohio and you're going to want to transfer your probation. I think, is that $100 fee, Mr. Moore, or 200?
200.
It's a $200 fee to transfer your probation to Ohio. You are going to need to report to our probation department, though, to sign your probation terms and effectuate that transfer. So you'd want to bring the $200 when you report. Mr. Moore, when do you want him to report to you?
Next Tuesday, 10 a.m. And that the $200 is a money order or cashier's check, please. Thank you.
So you don't take cash?
No.
Okay. So, Mr. Demolan, you need to report to our probation department to Mr. Moore next Tuesday at 10 a.m. And you're going to need a cashier's check or a money order for $200 to transfer the probation to Ohio. Do you understand that?
Yes, Your Honor.
All right, we are going to mail to you in an envelope 3 copies of your notice of right to appellate review, along with a self-addressed stamped envelope. The first copy is for you to initial and date to acknowledge you received the paperwork. The other 2 copies are for you if you wish to appeal the sentence. You would fill out the information on the form and mail it to the address listed on the form within 42 days, or even just put it in the envelope. When the one that you initialed and dated for our records, just put it in your mailbox or drop it off at the post office. And anything else, Mr. Moore? And it will be under 7411, of course. So, Mr. Moore, anything else?
Nope, that'll be it. Thank you.
Mr. Dagger-Margosian?
No, thank you.
All right, you're all set, sir. Thank you, Mr. Demolan.
Thank you, Judge Elmo.
All right, thank you. Bye-bye.
Bye-bye.
All right, so Mr. Coleman, I have your attorney here.
Judge, I can, a couple things. Number one, my office told me that Ms. Under would be handling, I'm happy to step in and do it right now. I would just need a second to speak with him.
Yeah,
Okay.
I mean, if you're happy to do it, that's fine.
Yeah, that's,
I just figured since you were his attorney.
yeah.
So, Mr. Coleman,
And with the
Mr.
court,
Dagger-Margosian is gonna go back in and Zoom, all right?
I just went to court yesterday, Angela.
I know, hold on a minute. Just hold on a minute. I saw you. So give me just a minute. Mr. Coleman, hold on. Let's not talk right now. Let's get your attorney here, okay? Because I don't want you to say anything that your attorney wouldn't want you to say. And he'll discuss it with you and put on the record what we need to.
Okay.
Mr. Moore, I think we're good. Mr. Coleman is just a bond violation. I've attended far too many concerts in my life and I don't pick up that low. I've like shot my hearing. Oh, here he is. Okay. So I'm gonna let Mr. Dagger Margosian in and call the case, and then I'll put you in a breakout room, all right? All right. So this is in the matter of the people of the state of Michigan versus Joshua Glenn Coleman, file number 25-22283FH. This is Judge Olsaver file. Mr. Coleman actually popped in my courtroom yesterday and I sent him down to Judge Olsaver's courtroom. Judge Olsaver is not here today. Mr. Dagger Margosian is his attorney on the underlying offense and is kind enough to agree to stay to talk to him today, even though he's not the typical defender that represents on contempt of courts. So this is a complaint for violation of bond conditions. And the paperwork states that on June 11 of 2025 at 21:15 hours, said defendant violated his conditions as follows. He was in possession of methamphetamine. So Mr. Dagger Margosian, that is the information I have, and it was by a Deputy Esposito. Okay, so that is one, and that must have. So then, let me see here. Then I have a letter from Darren Coast, pretrial services coordinator, dated June 9 of 2025, stating that Mr. Coleman has failed to set up the twice weekly drug testing with him after he was released from jail on June 2nd of 25. Mr. Coast went to his last known address on June 5 and left his card and received no answer. Hold on, Mr. Coleman, hold on. I don't want you to say anything yet. I'm just gonna read this off. Your attorney, I will put you in a breakout room and he will talk to you, okay? So Mr. Coast said he left his card. He had not, and to this date, he had not heard from the defendant. He would be asking to speak with him if he appeared for pretrial, which I'm assuming was yesterday, and Mr. Coleman did appear, and I know that because he came in my courtroom, and Mr. Dagger Margosian, I'm going to assume you appeared on the record with him yesterday. So, Mr. Coleman, I don't know if there's pending charges from whatever this possession of methamphetamine is. Mr. Dagger Margosian, you probably get that information quicker than me. I'm going to open up a breakout room, and he's gone. He's already gone on a Polycom, so go talk to him. Okay, I'm going to. If I could. All right, we are going to step off a bench for a record. Evidently, I'm a slave driver. It was kind of chaos this morning. Yeah. I don't know what's going on. Is it a full moon?
I don't think so.
All right. All right.
Wasn't that any case? They were just.
I think we're just kind of, yeah, all over the place. All right. What time is it? Nobody showed up for that, so that's just our afternoon document. Oh, it's our afternoon. Go ahead, Dan. You're good.
Okay, yeah. And then. Yeah. Yeah, yeah, it does not. That was obvious. I'll set. Okay. Did you go water?
Yeah.
Good. You ready for the weekend?
What's that?
Are you ready for the weekend?
Is it right now?
I know,
want
I
it to be
wish, I wish. One more day, we're close. We're close.
You know, over at the office, John, whenever he walks in, I mean, it'll be a Monday. It'll be Monday at 10 a.m. He goes, Leo, is it Friday yet? It's like the funniest thing.
He's so crazy.
I know.
He's
And,
so crazy.
and Leo every time is just like, no, John, it's, you know, we got 5 more days here.
I'm sure just what he wants to hear.
Yeah, right. Sorry, Judge, thanks for the time there.
Oh, not a problem. I don't have anything else going on. It's just been a morning of chaos, so. I don't know why. Okay, we are back with Mr. Coleman. So, Mr. Dagger Margosian, have you had enough time to speak to your client?
Yes, thank you.
So, with regard to the possession of methamphetamine, I don't know, did Mr. Coast wanted to see him that day? I don't know if Mr. Coast saw him, so hold on a second.
Well, this chair.
Mr. Coast, I'm on the record with Mr. Coleman, and it's a Judge Olsaver file. And I do see a letter in the file that states that he has not been testing.
Judge, actually, he was on Zoom yesterday.
He was in person, actually.
Oh, yeah, correct. Yeah, you're right. He wasn't in person, and I did meet with him yesterday. And I did put him in the color system. And I did see he's back in jail. But no, we're all set up now.
Okay, thank you, Mr. Coast.
Thank you. Bye.
All right, so at least that letter with Mr. Coast is taken care of. So I'm not quite sure why he's in custody now, or was he arrested on this complaint for bond violation?
Judge, I can't, obviously, so what I can relate to the court is that there was law enforcement interaction last night. He hasn't been charged with anything, obviously, from last night. The bigger issue was, from my understanding, was the drug testing, which he, as the court indicated, he came into court yesterday in person, walked to court. That case was adjourned. And then he set up the drug testing with Mr. Coast. Just as an aside, the underlying case, the 22283 case, it looks like that's going to be resolved at the next court hearing by way of misdemeanor. He's needing to be placed on probation, but I don't want to get too ahead of ourselves. Regarding what he's in jail for is just that he's not being held in on anything other than this bond allegation. And again, I'm not sure charges are going to even pop up from the law enforcement context. So.
Okay, okay. So we don't know if there's going to be new charges?
We don't know. From what my information, and I was coordinating with the prosecutor's offices, it may or may not, it's kind of, is going to depend on what happens on the underlying case and going from there.
All right, so how are you gonna plead him on the bond violation?
Well, I guess.
Probably not guilty because you can't make an admission.
It's that, and it's also, he's taking care of half of it, so if we can just maybe push that out and I can deal with that with Judge Olsaver.
Hold on, Mr. Coleman. Now, Mr. Coleman had said something about treatment. Do you want Mr. Coast to find a bed for him in an inpatient program?
Mr. Coleman was looking at.
Hold on, okay, go ahead.
That's what he was gonna indicate, is that he has already looked into it.
I know he's looked into it, but I could get him a bed.
No,
and it's hard to get a bed on your own.
I understand.
So he can look at it. Where'd you get a bed at?
Spira, they called me back. When I left court yesterday, they called me back and told me this. I was supposed to go today.
Okay, well, hold on.
So what I would propose to the court is holding off on that plan now, and if as part of probation. If that's going to be required, then so be it. But I think for now.
I think he wants to go. I think he needs help.
And he's indicating that he has a bed set up.
Where is this at, Mr. Coleman?
It's in Ann Arbor. I just don't want to sit in jail. Sitting in here does
Okay,
nothing.
well, that's
good
what
for
we're
my
talking about.
mind.
Hold on, Mr. Coleman, hold on, because I don't want you to say anything that could be used against you in case there's new charges. So, okay, so he is charged, his underlying charge is methamphetamine. There are these allegations that he possessed methamphetamine yesterday. You know, I think it's appropriate that he goes to treatment. And so you have a bed you set in Ann Arbor?
Yes.
Are you
yes.
talking
I
Dawn
got-
Farms?
No, it's Dawn Farms, but it's a spare location in Ann Arbor. It's not the actual farm.
You're talking about Sparrow Hospital?
Are
you saying Sparrow?
Sparrow. SPARRA.
All right,
It's
so,
a Dawn Farms.
okay, so Mr. Coleman, just to get this on the record. So a contempt of court for a bond violation could carry up to 93 days in jail. And your attorney has discussed the bond violation with you. So how do you want your client to plead on this?
Your Honor, regarding the bond violation, I'm asking for not guilty at this time.
Okay, so I'm gonna enter a plea of not guilty on his behalf. So then, with regard to on the bond violation, he says he has placement. What are you asking the court today?
Your Honor, I'm asking the court to release him on a PR with the understanding that this rehab is in place, but also, I think importantly, is now that he's set up with drug testing, we can monitor and make sure and monitor him on bond. And again, the ultimate result of the case is, I would anticipate, it will put him on probation, which will be further monitored. So I think he's on the right path. He does need to take accountability and make sure that this sort of thing doesn't happen. But for the time being, as it's pre-trial, lack of conviction, that sort of thing, I'd ask the court for a PR at this time.
Okay, so Mr. Coleman, I am going to release you on a PR bond. When's his next court date?
July 9.
July 9. All right. So, Mr. Coleman, I am going to give you a PR bond on this. I am going to enter a plea of not guilty on your behalf. So, Mr. Coleman, you are a very young man. And what I will tell you is that methamphetamine is probably one of the worst things you can do in terms of addiction. So, Mr. Coleman, a couple things. I'm going to release you. If you have placement, I want you to go to that placement. But I want you, when you get there, to give, let me call Mr. because I don't know this.
That's what Derek told me to do. And I called him and asked him, I said, you guys gotta let the courts know. They said, oh, you do for sure do that.
Okay.
All right, Mr. Coast. So Mr. Coleman said he found placement with a facility.
Okay.
In Ann Arbor. And can you spell it for me, Mr. Coleman?
I think it's spelled SPARRA, Sparrow.
He thinks it's Sparrow, SPARRA.
And Judge, that's actually part of Dawn Farms.
Okay, so Mr. Coleman, how are you going to get there?
I have my girlfriend to take me, or my stepdad to take me. I couldn't.
Okay, hold on. Just answer my question and stop talking, because I don't want you to say anything you shouldn't say. So he says he's going to be going there today.
Okay.
And so what I'm advising him is that when he gets there, that he provides a consent for you to verify that he's there.
Perfect, Judge.
If you don't go there, Mr. Coleman, I need you to report tomorrow to see Mr. Coast. Okay? Because I'm concerned with your addiction issues that you're not going to have support in the community. So if you can't get inpatient, Mr. Coast can head you in the direction of outpatient, all right?
Can I say one thing?
Maybe. Go ahead. Don't say anything that would get you in trouble.
I won't. Look, I don't ever come to court. Okay, I don't ever come to court. I don't ever do anything to help myself, all right? The last one when I got out of here, I made a promise to myself that I'm going to do better and not just say it. And that started, got to start somewhere, and that started by going to court. I called
Yep, and
Sparrow.
you are, so I'm gonna
they-
stop you there, because I know what you're saying. You are here, you are showing up, you are asking for help, and that is a change for you, right?
Yes.
So I'm glad, and that's what we want. We want you to seek out help, because if you seek out help, you get in less trouble. You get that?
Yes.
So if something happens and you can't get into Sparrow, go to Mr. Coast. He will help you. Okay?
The only way that I won't be able to get in the Sparrow is if I missed their call, like they told me to be prepared for.
Well, I'm letting you out of jail now, so go check your voicemail. All right? All right, but if you don't get in today, I need you to report to Mr. Coast and he can give you some direction, all right?
Report on immediately.
Hold on, Mr. Coleman, Mr. Coast says what?
Josh, if you do go to Sparrow, I mean, as soon as you arrive, I would like for you to give me a call. I gave you my card. I don't know if you still have that.
I still got it in my pocket.
All right, so if you go there, when you get there, call Darren once you settle in and let them know you need to call your pretrial services coordinator, all right?
Yes, ma'am.
And Mr. Coleman, you are always free to come to the courts as well to seek assistance, okay?
Yes, ma'am.
All right, behave. Thank you.
Thank you, Judge.
All right, bye, Mr. Coleman.